Let's talk about the American legal system. We can't talk about a body of law without understanding how the American legal system works. So, let's start with law. What is it? What is a law? I like this definition: rules that attempt to guide human conduct and a set of governmental sanctions that are applied when rules are violated. So we have some guidelines or rules that govern us. If we violate them, we can be sanctioned. There are 5 sources of law, or where laws come from. These are the 5 number, I guess there'd be 6. I'd like to lump the executive orders and the administrative rules together, and I'll tell you why when we get there. But we have the common law, equity law, and in some cases, you might see, if you're taking another law class, or you did take another law class, you could see common law and equity law lumped together. I like to treat them differently. Common law, equity law, statutory law, constitutional law, and executive orders and administrative laws are the various areas of where the laws come from. So let's talk about each one of them separately. We start with the common law. This one has been around for a very long time. It's also referred to as judge-made law. It might also be referred to as case law. And what is it and where does it come from? It's developed out of England, 11th century, and it was the system that was commonly used through England and into the colonial American times, and still is today. I mean, we've adopted it, and and I'll tell you where we're going to cross paths with it in this course. But it's worked out after consideration of other cases. It's judges and jurists, or lawyers, for another fancy word. Jurists is what they called them back then. And it's created over time after consideration of many cases involving similar facts. Judges look to past cases and follow what has been done in the past to resolve current issues, and it kind of develops over time, and it's based on the people's customs at the time to develop this foundation. Of course, over time, and as time has passed and society has changed, some of these laws are still in place but may not be enforceable. Like there's a law in Massachusetts that says you can't remix the national anthem or dance to the national anthem. In Iowa, you can't refer to margarine as butter. So there's some strange laws that still exist on the books, but had reason to be developed when they occurred. So judges decide these cases after consideration, like I said, of many other prior cases and decisions, and they develop over time. And what we call these prior decisions, very, very important concept, is precedent. Another term for it is called authority. Because once the law is established, well, let me go back. Why would we have precedent, or something is, a rule that has been established by a court in a prior case that can be referred to for guidance in deciding later cases? That's the definition of it, and it sounds nice and warm and fuzzy again when it says, oh, you can use this as guidance. Courts use it pretty strictly. I'm usually asked in court, what's your precedence or authority for that, Ms. Fox? Judges want to look to see what has been done in similar cases in the past and hopefully follow suit or adopt it. Consistency, right? If courts are free to change their mind whenever, then you don't really have any consistency, and people don't know how to behave in society. So we have precedent. But does that mean it can never change? Of course it can change. And like I said, it's important for consistency, so we know what laws are the laws, or what we can do in certain situations, so lawyers can consult and advise their clients, hey, this is the situation, this is what courts have done in the past, this is what I expect they would do in this case. But it can change, all right? They can change, and we're going to talk about that in a second. And I also ask the question, does a court have to follow it? Generally, they do. Have to is a strong word. But if there is a court in a higher, and we're going to talk about the court system, If there is a higher court in the state, let's say we're in New York State, and as you'll see in a second, we have a low-level court and we have an appeals court or a court that sits higher than that lower court. If that higher court has made a decision, that lower court has to follow it. That's precedent, and they have to follow it. So in some instances, they have to follow it until the one above them has changed it. We call this fancy Latin term stare decisis. Let the decision stand is what it means. Now, I'm going to go back to can it ever change? What if there's more than one case that has similar facts? We're going to talk about how, and you may understand that from state to state, the laws can be slightly different. Interpretations can be slightly different. So you can have the same set of facts in the state of Vermont as you do in New York, and the courts could rule differently, even based on their precedent that they have in the state. So let's talk about what courts can do. Courts have options. Yeah, they have a case in front of them, and they're reviewing the facts. And let's take a copyright case. One of the common types of cases is usually arguments over fair use. And we'll get to fair use towards the end of the course, but generally it's you've used somebody else's work of art, movie, picture, music, whatever, without their permission, and you're being sued, and the response or the defense is usually it's a fair use. And there's lots of cases. So if a court is determining in New York State whether or not your use of a particular work, somebody else's work without their permission, is fair use, they are going to look at preceding cases, the precedent, to determine whether or not this scenario will fit the particular ruling in that fair use case, and they can accept it and apply it and say, yeah, this is a fair use, no, this is not a fair use because of this prior precedent case. They can modify it. They can make changes to that law, and when they do, they have to tell the reasons for doing it. They can say, yeah, we need to update it because in that case we were dealing with music, and today we're dealing with a photograph, and they're slightly different works of art, so maybe we will consider it a fair use in this case, as it wasn't in the precedent. Can they distinguish? Yep, they can say, well, this doesn't even apply here. That precedent doesn't even apply here, and we're just going to do something completely different. And ultimately, they can overrule that precedent for various reasons. Normally, they declare it old law, or just flat out wrong. That was the wrong decision to reach. What might cause something to be overruled? Different knowledge, factual knowledge and circumstances that what we know now, we didn't know then. Technology, for instance. Social media causes a lot of copyright issues. The social mores or values of people, the judges on the court who are making the decision. We see this a lot with the Supreme Court. So these are some of the factors that would determine whether or not precedent would be overruled. So where do you find this common law? It's contained in hundreds of thousands of decisions handed down by courts from way back the 11th century. And generally, and they still do, they keep volumes and volumes of books. You can find them in books. There's usually what they call a citation, or I call it an address, usually the case name, Smith versus Jones, with a little, a number, consists of numbers and letters next to it. That's how you locate it in the books. Nowadays, you can just type that into the internet, and more times than not, it's just going to come up or direct you to the right spot. So what's the remedy at common law? Think money damages, okay? Common law, money, because that's going to distinguish our equity law. So if we're suing somebody, you got sued for using somebody's work of art, you claimed it was fair use, and the court said no, That's not fair use. Guess what? You got to pay him. You got to pay this person for the use that you use that for. Equity law. What is it? This is the law that allows relief only when a legal remedy, money, common law, is insufficient or inadequate. We're going to talk about some examples here in a moment. Where does this come from? The same exact place as our common law. It's developed over time. Everything is the same that I've told you up to this point. The only difference is what you get in the end. This is how it differs from common law. That's why I like to keep it separate. Even though equity law is a form of common law focuses on paying the harmed person money. Okay? Equity law is based on fairness. All right? And it's going to address concerns that fall outside those money remedies. I know this is a nice, big, long slide, but let me kind of condense it and pick it apart for you. So if money isn't going to help the situation, you are going to seek these three things. Now let's go back to you're the party suing. I'm suing you for using my song. You say it's fair use. That's your defense. It's fair use. And I have to go to court. I find out that you're using my song on your webpage, and I wanted to sell it to Disney to use in a movie. I have to go to court. I want to stop you from using it. I don't want money. Even though money will be nice, I want you to not use it. So I run to court without your knowledge. I run to court. I file some paperwork, and we'll talk about the particular paperwork in the next section. We're talking about what I'm looking for in the end. I run to court. I give the court my paperwork. The court reviews my paperwork, and if they find that I have a valid argument or a valid issue, they're going to give me something called a temporary restraining order, TRO. You may have heard this relative to like domestic violence kind of cases. It's the same kind of concept. And I take that and I have it served upon you, because you don't know I just did this. I have it served upon you that says stop using my song. It's only temporary, TRO, temporary restraining order. Stop using my song. The paperwork will also say, here's our court date. You got to come ASAP. And it's usually within at max 14 days. They don't, in this kind of situation, they don't last that long because the court hasn't heard your side. They're not just going to give me what I want without hearing from the other side. So they have a little mini hearing, because they want to hear what you have to say. But in the interim, you don't get to use the song. So then we go to court for the judge to kind of hear what your point of view is. And they want to determine whether or not there's some validity to the merits that warrant a full-fledged trial on the issue. And if I succeed at the hearing, the court's going to give me a preliminary injunction. It's going to replace the temporary restraining order. They're going to give me a preliminary injunction, and what that means is you cannot use the song while this case is pending. I'm going to get you to stop using my song while the case is pending. Then, at some point, there'll be a trial. Witnesses will come in and testify and all of that if it goes that far, if we don't work out an agreement beforehand or some sort of settlement. And if I win, the court is going to award me a permanent injunction, which is a final order of you can't use this song. You're stopped from using the song. And my goal was to get you to stop using the song, not any sort of money, even though I might get some some minimal money out of that if you in fact used it. If I just learned you were going to use it, you hadn't used it yet, but I wanted to stop it, this still comes into play. So what we get here, what I have to prove to get this is, and what I like to call these remedies, I'm either preventing something, I'm stopping someone from doing something before they do it, or I'm prohibiting. I'm stopping the doing of something that is currently happening. And that's what equity relief is about. Money isn't going to satisfy what I want to have happen. So the test is an individual must prove that they are about to suffer a serious, irremediable wrong. Basically, there's no adequate compensation. And that is, if you use my song, Disney isn't going to buy it. And where am I going to make more money? Probably selling my song to Disney than making a deal with you, right? That makes sense. So that is equity law. I have an example here, but I already just took you through the example. That was the example I was going to give you. We're going to move on to the next body law. And by the way, before we do, equity law, that example that I gave you, that is one of the primary sources of relief, one of the primary requests of relief that plaintiffs in a infringement suit or a violation of copyright suit is asking for. Sure, there are a lot of cases where they want to be reimbursed. We're going to talk about some of those cases, very popular cases. I'm going to let the cat out of the bag. We're going to talk about Katy Perry, who was sued a year or two ago over her song Dark Horse and had to do a big payout. So both common law and equity law will play a role. Equity law more so than common law a lot of times. All right, statutory law. These are law. What is it? Where does it come from? How does it differ from common law? Where does it come from? It's laws that are created by our elected officials, our Congress, our, the New York State legislators, the Assembly, and in New York it's the Assembly and the Senate. In this, like city area, in cities, they have common councils that they create statutory laws. And they, like I said, they can be local, state, or federal. And we're going to be dealing with a lot of statutory law. Copyright law is statutory. It's in the federal code. It's created by Congress. We'll touch on next week patents and trademark. They're statutory laws. They are created through the federal government. The point of statutory law, what they look at is, when I say they, legislators, they're dealing with problems that could come. They're anticipating problems. They want to pass laws before the problems happen, or in response to problems that have happened. Or maybe we should change this. And these are things that would affect large bodies of people as a whole. And like I said, copyright and trademark laws are statutory. So is the patent law. Criminal laws are statutory. Where do you find all of these things? Again, in books, but everything is online. You can find any of these laws online. If you're looking for the Federal Copyright Act, you just type in. You can even type in copyright laws and the federal. Type into Google, and the federal copyright law will show up. It's actually linked on our Moodle page because I'm going to refer to it when we get to copyright. Sounds nice and easy, right? Statutes, legislators make them. These are our laws. We got to follow them, right? But I want to show you this example. Sometimes these laws have terms in them that needs further interpretation. Like this one here. It is illegal to distribute a violent video game to minors. And I'm a video store owner who sells video games. How do I comply with this law? Do you see any problems with this law? What do you think? Well, what's violent? What's considered violent? What I think is violent, you might not think is violent. Who is a minor? We might think, well, that's anyone under the age of 18. Well, sometimes minor gets defined differently depending on what body of law we're looking at. Who can constitute a minor? And how about, what does distribute mean? Does that mean sell, rent, lease, give out? So these are the things where a court has to come in. And if there's a challenge to, someone is arrested for selling a violent video game to a minor, the argument is Well, I didn't know that game was violent. I didn't know that person was minor, or who is a minor. Like, they're 17, or maybe they're 18, but the minor statute's 21. Well, yeah. So courts have to come in and interpret these kinds of statutes. They call that judicial interpretation, statutory construction. They will look to what the legislator meant. What was their intent to do with this? And they do this by looking at the history of the creation of the law. This isn't, when legislators make law, it's not poof, there's this law, I got this great idea, we're going to pass it. It goes through committee after committee and review, and other people review it, and they write their comments. So you can find extensive writings on laws and determine how they got to where they got with the law. But if a court can't figure it out, then the statute gets tossed out as unconstitutional. And as a matter of fact, this law that I just showed you with the violent video game was in fact a law in California. And despite the fact that these questions couldn't really be determined, the big factor was when the court tossed it out as unconstitutional, they said it was a violation of free speech, because you are entitled to create violent video games and have it be available without restriction. So, anyhow, that is our statutory law, and on the heels of talking about something being unconstitutional, our next body of law, constitutional law. Where does it come from? Where do you find it? And you're probably shouting out, the U.S. Constitution. Yes, but where else do we find constitutions? Every state has their own constitution. City charters are also considered as a form of constitution, and this is it provides the plan for the government, the organization, establishment of the government. It outlines their duties and their responsibilities and their powers, and it also guarantees certain basic rights to the people that it governs. Now the question is, who does the Constitution protect? Constitution protects basic rights of the people. Who are the people? You might say the citizens of that state or that city or the U.S., and generally I would say yes. However, the Constitution, especially all of the constitutions, but if you are here illegally from another country, you are entitled to all the basic rights under our Constitution while you're here. So if you get arrested, you're entitled to the judicial process that is available through our court system and all the rights available under the Constitution. So if you are on U.S. soil, you have protections under our Constitution. And who does it protect us from? Government action. Not each other, not individual to individual, government action. That is the key to the Constitution. The Constitution outlines, and I said it at the end of the last week's class, the Constitution is where Congress is provided their power to create laws for inventors of patents and authors for their creative works. And you'll see that trademark law is also governed under the Constitution through the Commerce Clause. So the Constitution kind of plays a role here. You're also going to see, as we move forward, arguments relative to free speech and free press as it relates to the use of others' works. It might be a news outlet reporting on the fact that there's a concert, Lady Gaga concert here in town, and you show, you play a clip of one of her recent songs on the news. The argument is, well, was that copyright infringement? You didn't get her permission to do that, or is it some sort of fair use, or is it free press, or is it free speech? So you'll see the Constitution intertwined during this course. and the U.S. Constitution is the supreme law of the land. Any other law or constitution that conflicts with it is unenforceable. I showed you that with the example on the video games. It is hard to change. You actually need it to pass in the House and the Congress, but not just in the all of Congress, in the House and the Senate. And it also has to be ratified by 2/3 of the states. So that's very hard to do. It's fairly short. There's only 27 amendments, and the first 10 are called our Bill of Rights. Hopefully that's a recap from a political science class or maybe a history class in high school. But constitutional law has developed over time by courts through their interpretation of the Constitution, i.e. and then their development over time is all called precedent. And the court that creates most of this determination is our Supreme Court. We'll talk about the Supreme Court in more detail. Executive orders and administrative orders. Where do they come from? Where do these guys come from? Executive orders. I gotta flip my page here. All right. The executive orders, they come from our high elected officials, right? The president, if we're talking about the United States, the governor, if we're talking about states, and the mayor, if we're talking about cities and so forth. They issue executive orders. You might have been hearing a lot about executive orders being issued from our governor here in New York, as well as the president. Generally, we wouldn't be talking about executive orders in this case. However, in 2018, President Trump did issue an executive order that extended some copyright durations. So we're going to talk about that when we get to durations. At the close of the expiration of some pretty big works owned by Disney. I don't know if there's any influence there, but we'll talk about it when we get to duration. So we will be talking about executive orders, and these are the powers and the rules for issuing these. The constitutions govern the ability and their powers to do so. It's not that they can't be challenged. They certainly can be challenged, and Governor Cuomo has been challenged often in the last few months relative to his executive orders. And what I mean by challenge, a court can overrule it. But that's as far as we will talk on executive orders. I don't want to muddy the waters. Administrative rules. We'll talk about these. These are created by government agencies. Who's a government agency that we might be talking about? The U.S. Patent and Trademark Office, the Copyright Office. There's an actual office for the copyright, and they govern types of technical and complicated matters that might come before them relative to filings. You'll have to register copyrights, and if there's any issue regards to those, that's what they deal with. They won't deal with a case involving infringement or fair use. That'll go directly to the court. But if it's their laws that govern what they do within their system, they will administer the rules and have appropriate hearings on the issues. Members of the agencies are usually appointed by the government officials, and like I said, their tasks are very narrow. But regardless of what kind of decisions they make within their agency, they are always appealable to some higher level, a board in their agency, and then ultimately the court can review the decision and the circumstances. So there is a code for federal registration of copyrights that would be governed under that'll be part of this administrative laws. So we will touch on that, especially when we're talking about the formalities and the registration process. So these are the orders, the sources of law. Next we are going to jump and talk about the actual American legal system, the federal court system, and the state system.